are you guys today? Okay, so what I want to talk about is, well, I had been looking into different cases, mostly around fraud, but just in general, recent situations that the Office of Disciplinary Counsel had published, about how they were handling cases, just out of curiosity for thinking about what could happen with my case based on looking at past patterns and past history. So, just kind of thinking about what could happen because I still don't know shit, but and when I was looking through some cases, I found one that was kind of entertaining to me. This is about the Randazzo family, which is kind of a big family in not only New Orleans, but also like all of Louisiana, basically. Particularly southern Louisiana, if I'm not mistaken. But yeah, so I just wanted to go over this situation. I had read about half of the lawsuit, or is it a lawsuit if it's a charge from the state board? I don't know if that's the right word. I had read about half of the charges from the Louisiana State Board against Mr. Salvador Randazzo. I don't even know if I'm saying his name right, so sorry if I'm not. But yeah, but I read that and I was like, wow. So it was kind of entertaining to me. Some of the things that were happening I did find amusing, and so I'm just realizing now I meant to pull up something, but I forgot to, so whatever. Anyway, but I don't know, it was just really funny to me, like, the situation which was happening, particularly when you think of, like, what is considered professionalism, and, when you look at, like, when I think of, like, ways that I've been treated, and I've never done anything nearly as like this in their workplace. I don't know. But we're just gonna read the documentation. And yeah, but before we do, I'll explain who the Randazzo family is and give you some context for the documents that we'll be reading as well. So I'm rambling too much. I'm just gonna roll my intro and then let's just go ahead and get right on into it. Hi, my name is Alexis, also known as Lexi or Deaf Child. I was born deaf, hard of hearing. I began doing business as Deaf Child 2013, marketing 2011, sales 2009. I've earned 50 plus certifications in marketing and sales. My Bachelor of Science from Loyola University, New Orleans, with a music industry studies major and a business administration minor. Deafness runs in my family genetically. Speech is not fully accessible to me. Anyway, I'm here to bitch about whatever the fuck is on my mind. So here we go. Visit my site at noladeafchild.com. Okay, so first up, I'm sure a lot of you people watching do know what a king cake is, but I just want to explain what a king cake is just in case anybody's watching that doesn't know, because not everyone does if they're not familiar with New Orleans or Louisiana culture. But basically, king cake, it's a seasonal cake. It's kind of, there's different methods of making it. So some people will kind of make it more of like a cinnamon roll base, and some people will make it more of like a brioche bread base. But in a lot of situations, it's kind of like texture-wise a combination between a bread and a cake. And it's often as a base starter, a traditional or simple form of king cake would traditionally just be like a cinnamon-based bread. But oftentimes, they'll often do other fillings, typically with cream cheese. It could be like strawberry, or something of that nature, or just regular cream cheese or something like that. And it's usually always also topped with crystallized sugar. Actually, I don't even know if I'm using the right words to describe the sugar. Granulated sugar is what I think it is. I honestly, look, don't look at me like that. I don't know the right word to call the fucking sugar, but it's that grainy fucking sugar shit, and it's usually colored like purple, gold, and green, and that's how it's served. I don't know too much about the history of king cakes and blah blah blah, so I'm not going to go into all of that, but I, just to give people who are unfamiliar, it's usually traditionally served between Fat Tuesday, Ash Wednesday, usually don't eat it anymore. Fat Tuesday is typically the last day to eat it. and it's usually served between, I think it's like, what is that day? I forget. Look, I'm not Catholic enough to remember the Catholic holidays, to be honest. But during the time of Catholic fasting is when we usually do the king cake, if I'm not mistaken, around that time period right before. And then it's just, in season from the beginning of when the fuck Mardi Gras starts. Shit, I'm blanking. I feel like I used to remember this shit. But you know what I get confused? Like Good Friday and Ash Wednesday and all of that shit in relation to everything. You know what I mean? But yeah. Alright, I'm gonna stop talking. But anyway, fucking, well, I say I'm gonna stop talking, but I'm gonna keep talking. But I'm gonna stop talking about that. Alright, so the Randazzo king cake family tree. So this little diagram is a more descriptive version, and then I got another diagram which is more of a summary of it to show you after this. But basically, so first of all, in 1965, Sam Randazzo opened Randazzo's Highland Bakery in Violet, Louisiana with his 3 sons, Anthony, Lawrence, and Manuel. In 1992, Manny Randazzo opened what is now called Manny Randazzo's King Cakes in Metairie with his wife, Diane. They would later divorce. 1994, 3 of Lawrence's children and 1 in-law, which would be Felix Forget Jr., founded Good Children Bakery Shop in Moreau. A second location opened in Chalmette, but Hurricane Katrina destroyed both bakeries in 2005. Number 4. In 1997, Tricia Randazzo Zorns opened Randazzo's Camellia City Bakery in Sidell with her husband, Louis Zorns. Item number 5 here, 2006. 1 year after both Good Children Bakery shop locations were destroyed, Joel Randazzo Forget and her husband, Felix, opened Nana Randazzo's Bakery in Covington. Additional locations would follow in Chalmette and Mandeville. Here we go for number 6, 2008. After her divorce with Manny, Diane founded a bakery, Diane Randazzo LLC. The courts ruled she couldn't use the Randazzo name for her king cakes, so the business took on business partner John Kaluda's name instead. Kaluda's king cake in Harahan makes a cake similar in some ways to a Randazzo's king cake, but nowhere near identical. Item number 7, 2015. Kenny and Nicholas Kaywood opened Kaywood and Randazzo's Bakery in Chalmette in 2015 with mother Susan and father Kenneth. Alright, so it's a bit complicated, as you can see. And so who we are dealing with is Mr. Salvador, Mr. Salvador, fucking Randazzo, whatever his name is, I'm sorry. Okay, so, but I don't know, to be honest, if that's the same guy as the Randazzo's Good Children Bakery shop, or if that's one of his family members. To be honest, I have no clue, but I am fairly certain that they're all related, if I'm not mistaken. I could be wrong. So this is the kind of shortened summary of the Randazzo family business tree here. So at first start, we have Salvador Sam Randazzo. He opened Randazzo's Highland Bakery. He had 3 kids, Anthony Randazzo, Lawrence Randazzo, and Manuel Manny Randazzo. So Lawrence Randazzo, I believe him and his kids, if I'm not mistaken, opened Randazzo's Good Children Bakery shop, if I'm not mistaken. Wasn't that the one, the Good Children was the one that was destroyed though, right? So yeah, if I'm not mistaken. And then Joel Randazzo and Felix Forget Jr. ended up opening Nana Randazzo's Bakery. Okay. And then also Manuel Manny Randazzo Sr., his kids, Mandy Jr. opened first there was the Randazzo's Camellia City Bakery, if I'm not mistaken, with Trisha Randazzo's, right? Didn't that one open first? The Camellia Bakery? Yeah, that one opened in 1997 first. And then after that, Manny Randazzo King Cakes had opened with Diane Randazzo. But if I'm not mistaken, when she got divorced from Manny, she opened up Kaluda's King Cake. And there was a legal dispute about whether or not she could sell king cakes with the Randazzo name. And then, and then Joel and Felix, they had opened Nana Randazzo's after the Good Children one closed. So that's the whole thing, right? So I believe if you've spent any amount of time in New Orleans or Louisiana, in the southern Louisiana area particularly, and you've been around for Mardi Gras, you most likely have had one of their king cakes, probably, you know. They did make their mark in the king cake industry. So yeah, so this is the family that we're going to be discussing, and this is the family for the context of the following legal documentation that we are now going to be reading. So yeah, let's get into this. So, I'm just going to be 100% clear. I don't know with 100% positivity, because I did not look and stalk into these bitches about who the fuck this specific Salvador Randazzo is. I'm not entirely sure where he falls in on that family tree, you know, which one of those people he is, if he is on that tree, or if he's just related to them and also has the same name, because I know in a lot of families, you know, there'll be like 20 fucking Alexes, for example, in some families, or like 15 fucking Marias, you know what I mean? You know, in certain families, names just everybody's named the same damn thing, fuck it. I don't know if I'm wrong for saying that, but like, for example, you know, my dad's family, he's one of 11 kids, and like every generation, they have a lot of kids, you know, and I literally had like over 40 first cousins at this point. And they all had kids, you know, and all of that. And so there are certain names in my dad's family that are very common. There's a lot of Carsons, for example. There's a lot of Roberts, for example. You know, so I do know that sometimes, you know, in families, names can really go around. So I don't know which Salvador Randazzo this is, but what I am very certain of, I believe he is related to and part of that Randazzo family we just discussed. All right. This is Henry Salvador Randazzo from the Supreme Court of State of Louisiana. Let's see, and it's got from the Office of Disciplinary Counsel, and it's got findings and recommendations for the formal charges here, and it looks like this was filed September 10th, 2025. It says a suspension was imposed. Have no fucking clue what C per curia means. And then this one guy, Crane J, dissents and would reject the proposed discipline as too lenient. He said, nah, we should have punished him harder. I found it a little entertaining. When seeing this line, I was like, oh, I have to keep reading this one. You know what I mean? Like, yeah. So, all right. I feel like after I finish reading this, I might look up a little bit like who the fuck this Salvador Randazzo is, and if it's not too creepy, I might show that. But anyway, so Supreme Court of Louisiana. This is item number 2025 B0772 in regarding Salvador Randazzo, and this is an attorney disciplinary proceeding per curiam. The disciplinary matter arises from formal charges filed by the Office of Disciplinary Counsel, ODC, against respondent, Salvador Randazzo, an attorney licensed to practice law in Louisiana. Not for long. I'm just kidding. Actually, are you technically still licensed if you're only suspended? I mean, I guess you're temporarily unlicensed for the suspension? I don't know. Is unlicensed even a fucking roadman? Anyway, underlying facts. The following counts are based on 3 disciplinary complaints filed against respondent by Judge Darren Roy, Division D of the 34th JDC. I have no fucking clue what the fuck a JDC stands for. If I were bullshitting, which I am, I would guess it would have be some bullshit like judiciary, division, court, I don't know, district court, judicial district court. What the fuck is it? I don't know, man. I have no clue what the fuck JDC means here. I'm just bullshitting. Okay. Then it says respondent who is a litigant in the case of Salvador J. Randazzo individually and as executor of the succession of Lawrence J. Randazzo and succession of Josephine L. Randazzo and Lorene A. Randazzo versus Patrina Ruiz Imbraguglia, Alex Ruiz, Gerald J. Ruiz Jr., Christy Ruiz Orso, the heirs of descendant Camille Ruiz, Manuel J. Randazzo Sr., Lina Torres Nunez, Sidney D. Torres III, Lina Torres, and Randazzo Property Corporation. Alrighty, so you see, these are some very familiar names, right? Salvador Randazzo, Lawrence Randazzo, Manuel Randazzo Sr. We just saw those names, right? So you can see why I think it's all the same people, the family. Yeah. So if you don't know who Sidney Torres is, I didn't even think to Google that. But you know, I'ma just Sidney Torres, New Orleans landlord. Let me just see what pops up here. Okay, well, he's being compared with Donald Trump, so that tells you all there is to say there. I don't know why I thought Sidney Torres had to do with owning properties. He is a property owner, but I guess a landlord is different. But why did I think, you know what? Hold on. Let me check something real quick, because if I find... honey, wrong button. My bad. Because if I find, let's see if I can find something in the Facebook group. What was his name? Sidney Torres. Why did I think... Okay, I apologize. I don't know why I thought it was, this guy that, maybe I'm getting him confused with another landlord, but I don't know why I thought it was this guy that was had to do with something to do with like real estate in Louisiana. Maybe I'm getting him confused with Joshua Bruno. I don't know. You know what? It all blurs together. But I remember Sidney Torres got real popular for some reason in Louisiana. I forgot. I'm gonna try to timestamp this shit, y'all. Apologies. I forgot why the fuck Sidney Torres was standing out to me. Let me Google Sidney Torres Controversy. See if that pops up anything. Oh, now I see why. Okie dokie. Alright. So, if you Google Sidney Torres Controversy, what you'll find is, you know, an article here about how a contractor was ousted in the French Quarter because of him. And then he's called literally a menace because of cancellations in contracts and things like that. You know, so apparently people are unhappy with him, but there was something to do. There was a dispute with this building, if I'm not mistaken, or with some shit in the French Quarter because he's known as a controversial real estate developer. Oh, god damn it. This won't let me look at it. I'm not about to look at ads. Look, you know what I'm going to do? I'm getting too far off topic. I'm just going to add a link in the description of this video real quick for the Sidney Torres Controversy. I just added a link to my Google search here. And that way people can go look up that information on your own accord. So I just copied a link to this search result in the description of this video. And from now on, and for now, we're just going to keep going. Okay, so, but yeah. So it's about basically like all of these families are pretty big. And then in New Orleans, I actually know of a different Imbruglia dude that's an attorney. I wonder if he still is. Anyway, but yeah. So fucking, there was a case here that was filed against the respondent by the Judge Roy. And he was a litigant. If I'm not mistaken, the difference between like that means they were litigating against him, right? If I'm not mistaken. Let me see. Well, it just says involved in a lawsuit. It can be the plaintiff or the defendant, apparently. I don't know. So he was involved in the lawsuit in the case of Salvador J. Randazzo individually, and as an executor of the succession of Lawrence J. Randazzo and succession. So this has to do with real estate. Where I get confusion though is, you see, where it has the verses right here, I think these people were on one side together and then these people were against each other, if I'm not mistaken. So I believe in the case that Judge Darren Roy was presiding over, I believe that was Salvador J. Randazzo individually, and as an executor of an estate for Lawrence J. Randazzo and Josephine Randazzo, and Lorene Randazzo. And versus, so if it's him versus someone else, they usually write it that plaintiff versus defendant, if I'm not mistaken. So I believe he may have been the plaintiff here, and the defendant may have been Patrina Ruiz Imbruglia, Alex Ruiz, Gerald J. Ruiz Jr., Christy Ruiz, or Orsa, I don't know if I'm saying that right. The heirs of the descendant, Camille Ruiz, Manuel J. Randazzo Sr., Lena Torres Nunez, Sidney D. Torres III, Lena Torres, and Randazzo Property Corporation. So it looked like he was trying to sue his own family, and regarding real estate succession, regarding inheritance. So, if I'm not mistaken, and again, I'm not an attorney, so I may not be processing this right. Okay, so that situation was assigned to Judge Roy. Now, count one of these, so that was me trying to process what case Judge Roy got involved in. Now we're back to focusing on why Judge Roy filed a complaint against Salvador. So, count one. In his complaint, Judge Roy alleged that between May 5th, 2021 and May 26, 2021, respondent made inappropriate statements in phone calls and voicemails to Judge Roy's office and staff. I feel like that's a really stupid thing to do. The statements include, but are not limited to: 1. Derogatory statements about parties involved in the litigation. It's your own family, man. And judges who presided over the case prior to recusal. Number 2, statements discussing the litigation. Number 3, questions to the judge's staff as to how Judge Roy would rule on various issues. Number 4, statements to the judge's staff of the actions respondent will potentially take in the future, depending on potential rulings by Judge Roy. Item number 5, statements discussing various disciplinary complaints respondent has filed against attorneys and judges. Item number 6, statements and questions towards Judge Roy's staff member pertaining to her family and work history. Number 7, statements about possible decisions from the Judiciary Commission. 8, statements referencing a non-involved judge who spent time in federal prison and that he wouldn't want Judge Roy to serve time in prison. And number 9, statements accusing Judge Roy of treating other parties more favorably than respondent. I mean, I would treat other people more favorably too if they were acting like that, but who knows? I don't know. Okay, so, but then again, a judge is supposed to stay impartial at all times, but what if the judge was staying impartial at all times, and the fact that he wasn't getting special treatment is why he was basically being like, well, now the judge is being mean to me. You know what I mean? But who knows? I wasn't there. I'm just speculating. So, next up it says, on May 27th, 2021, Judge Roy signed an order directing all parties in the litigation to contact the court and or staff via email only. Respondent forwarded documentation and emails to Judge Roy, Judge Roy's staff, the court reporter, and other parties to the litigation. However, the documents and emails dated before and after the court's order included unnecessary ex parte information and statements seeking to influence the judge, such as, I need the transcript to attach to my complaint against Darren Roy with the Judicial Commission, and statements respondent knew to be false or with reckless disregard concerning the qualifications or integrity of Judge Roy. Right out of the box on May 6, 2021, his bias came through. So I wonder why he was calling Darren Roy these things, like basically wanting to complain with him, calling him reckless and things of that nature. Alright, he wasn't calling him reckless. The complaint is saying that those statements were reckless. Okay, yeah. Life is hard. It's hard for me to process sometimes. Anyway. So then it says, in his response to a complaint, respondent defended his conduct and made several negative comments about the qualifications and integrity of Judge Roy. At his sworn statement, respondent admitted making the calls to Judge Roy's office and stated that he had the right to call the judge's office and that some of the statements to the staff included information contained in the public record and or that's been known to everyone in St. Bernard Parish Courthouse since 1941. Respondent admitted that he regretted only one of the phone calls as it contained statements that were not necessary for the judge to know, except at the hearing in the matter. The ODC alleged that respondent's conduct violated Rules 3.5a. A lawyer shall not seek to influence a judge, juror, prospective juror, or other official by means prohibited by law. 3.5b. A lawyer shall not communicate ex parte with such a person during the proceeding unless authorized to do so by law or court order. 8.4a. Violation of the rules of professional conduct. And 8.4d. Engaging in conduct prejudicial to the administration of justice of the rules of professional conduct. Count 2. In his complaint, Judge Roy alleged that respondent filed 2 pleadings that contained statements and accusations which respondent knew to be false, or, at best, demonstrated a reckless disregard of the truth concerning the integrity of Judge Roy. The first pleading, captioned Designation of Record for Appeal of Judgment Pertaining to Hearing of May 6, 2021, converted by 4th Circuit Court of Appeal from supervisory writ to appeal, contains the following statements. Darren Roy was busy serving Salvador J. Randazzo with every order he signed, except the order he was directed to sign by the 4th Circuit Court of Appeal. Salvador J. Randazzo, due to no fault of his own, but due solely to the contrivance of Darren Roy, was not provided the district court's order in a timely manner. Salvador J. Randazzo can only think of one reason why Darren Roy, trial judge, did not email his order signed on August 2nd, 2021 to undersigned counsel, and that is that he wanted the time limit to pass so that undersigned counsel could not designate the record and would have to pay to have the entire record copied for the appeal. This cost of copying the entire record, 95% of which involves other Randazzo properties and issues, would be prohibitive, and Darren Roy wanted this appeal to be stopped. Darren Roy believed, or believes, that compelling the payment of such a huge amount of money to get irrelevant and immaterial pleadings copied would be sufficient to deter the continued prosecution of this matter before the Fourth Circuit Court of Appeal. So if I'm understanding correctly, Mr. Salvador was accusing Mr. Darren of interfering with the case, and if I'm understanding correctly, he did so without evidence. Otherwise, this formal charge would likely not have gone through, potentially, if I'm not mistaken, right? So, am I processing that correctly? Who knows? I'm not an attorney. So, and these are statements that this count is claiming that Mr. Salvador made, if I'm not mistaken. The last one was, despite the I don't even know how the fuck to say this word. Is it machinations? Machinations? Book. Hold on.
Machinations.
Despite the machinations of the trial judge, Darren Roy and anyone else that he has had ex parte communications with, Salvadore J. Randazzo files this pleading. So, I don't know shit about the law, but are you supposed to talk about yourself in the third person whenever you're writing pleadings? Is that like normal? Is that just like what you do, like legal standard? Or can you write in first person when you are filing on behalf of yourself, or are you supposed to do it in third? You know, whenever I've had some mental breakdowns and I was copying notes from my notes and then sending them to somebody, I had forgotten to change pronouns, you know? So in situations like that, where I've written something for one situation or processing in one place, and then I put it somewhere else where certain pronouns or words need to be changed, I do understand, you know, fucking that up, or something, you know? But is it just, like, I was just curious, like, is it just normal to write in, like, third person about yourself if you're filing your own pleading as an attorney, or do you do, like, first person for that? I don't know. Anyway, so, then after that, it says, the second pleading, captioned, Motion for Recusal of Darren Roy, Judge Division D, 34th Judicial District Court. Ah, that's what it stands for, JDC, Judicial District Court. Okay. Shit. Anyway, sorry. Judge Division D, 34th Judicial District Court, Parish of St. Bernard, State of Louisiana, contains the following statements. Darren Roy, as trial judge, signed an order pursuant to the remand of the case, but Darren Roy did not email a copy to Salvadore J. Randazzo and did not have Salvadore J. Randazzo served with a copy of his court order. Darren Roy sat on the August 2nd order that he signed, letting time pass, which would have adversely affected the appellate rights of Salvadore J. Randazzo. To take this kind of action is nothing less than malicious. And most of these statements are in all caps, which I also find relatively entertaining. Apologies. So yeah, I don't know. Is it normal also to put, like, to write in all caps for legal formal proceedings, you know? Like, do I not understand the gravity of what this situation could be if it were to be true? Or is it just, in my opinion, does it come off as petulant potentially to use all caps in legal proceedings, right? Like, isn't that a little odd to do? Anyway, I don't think it made him look good, to be honest. And so, yeah, after that, the documentation says, in his response to the complaint, respondent denied that his conduct violated the rules, adding that he has the right and privilege to state what he believes is a reasonable conclusion in the pleadings he files. Okay, I agree that you do have your own right to have an opinion about what you can experience, but on another level, if you are going to the fucking, you can't upon information and belief your way into a fucking complaint against a judge. Like, you have to have some fucking evidence, right? Or am I wrong? You know what I mean? Like what? Like, yes, everybody has the right to an opinion about some bullshit, but does everybody have the right to enforce discipline on someone for shit they can't prove, for shit they just think? You know what I mean? I don't know. Am I wrong for spiraling about that? Like, I know there's some nuances there. Like, it's not just one way or the other, but, like, also, shouldn't there be some sort of structure? I don't know. Anyway, so then it says, his response also contains several comments that are either false or made with reckless disregard as to the truth or falsity concerning the qualifications or integrity of a judge, including but not limited to the following. Darren Roy will only do the minimum required of him. He says so in black and white. My statements point out that he may be lazy and have incompetent staff. Watch all the staff of his watching this like, the fuck, bitch? The fuck are you talking about? Who the fuck are you calling lazy? Anyway, and then it says, it appears that these two complaints from a district judge are an attempt to improperly and illegally tamper with my law license. So did he try to complain against the judge after the judge had already filed his complaints against him, and literally he had nothing to prove for what the judge did except for he basically being like, I don't fucking like this shit, so therefore fuck you? Like, it's okay to not like something, you know, someone does, or to be upset, but to claim someone is unethical just because you're unhappy with what they did is a different situation. It is one thing to, like, think that somebody is unethical or a situation is unethical, but if you're just saying that, but you're not making any arguments to properly explain or articulate what was unethical, and if you're not providing any evidence, then it does kind of look like you're just insulting someone for no reason. You know what I mean? Or am I wrong for thinking that? But yeah, fucking, so then it says, at his sworn statement, respondent was asked to provide facts or evidence to support the statements he had made about Judge Roy and his pleadings. Here we go. That's what the fuck I've been asking for. And then it says, respondent provided no facts or evidence, only his beliefs and opinions based on decisions and events that occurred or did not occur. Damn. Or did not occur. They're literally, they're like, yeah, this dick is just making some shit up. We don't know. Like, the fuck, man? Like, yeah. Like, just imagine being an attorney, like, being so pissed off that the judge made a ruling against you that you literally wrote the fucking judiciary committee or whatever the fuck it's called, like, upon information and belief, I don't like him. He's a poo-poo head. Make sure you know he's unethical. I'm just kidding, but that's just kind of how this comes off. Okay. So then it says the ODC alleged that respondent's conduct violated Rules 8.2a. A lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity? Shit. I don't think I'm saying that right. My bad. What's wrong with me? Falsity concerning the qualifications or integrity of a judge. 8.4a and 8.4d of the Rules of Professional Conduct. Yeah. Count 3. In his complaint, Judge Roy alleged that respondent filed numerous pleadings containing statements and accusations which respondent knew to be false, or at best demonstrated a reckless disregard of the truth concerning the integrity of Judge Roy. On October 27, 2021. Respondent filed with this court a pleading, captioned, applying for supervisory writ application from the ruling of the Louisiana Court of Appeal, number 2021 C0444, Court of Appeal, 4th Circuit, State, Louisiana, which contains statements about Judge Roy, Judge Hans, oh fuck, I don't know how the fuck to say that, Liljeburg? Yeah, I mean, no disrespect, I have no clue how the fuck to say that. Judge Hans Liljeburg and the 4th Circuit. Okay, before we read those statements though, I was just thinking, all of the people that Mr. Salvador Randazzo was suing for why he ended up getting complaints filed against him with the Office of Disciplinary Counsel, he was suing his family. Everyone in his family that he was suing are the people who are now the most successful in the king cake business of his family, if I'm not mistaken. So, why the fuck would you sue your family? Because now you're out of a fucking job and you can't go back to the family business because you just fucking sued them and pissed them all off, bitch. That's not very smart. If I had a family business, you wanna stay on good terms with your family for the nepotism, for the job security, really shooting yourself in the foot here, Mr. Salvatore. Yeah, anyway, so the statements he made about Judge Roy and Judge Hans Liljeburg, fucking that up, so sorry, were included but were not limited to, the 4th Circuit did not look very hard. The 4th Circuit rendered a feckless decision. Okay, so did the 4th Circuit not look through the documents, or were your documents just really fucking stupid? Because, okay, if you give them the information, they legally have to look at it. And so, in my opinion, I believe I organized, so I went through an EEOC complaint and I also went through an Office of Disciplinary Counsel complaint myself. I believe the way I organized everything in my complaint to the ODC was much better in my complaint to the EEOC. With my complaint to the EEOC, I didn't know what to tell them, and so I gave them all of the information, and I believe that was too much information. I had more time to work on my complaint with the ODC, and I was able to, at that time, better process all the information I'd already shared with the EEOC, and I believe I was able to therefore compile and document and give them something that was more concise and really outlined and mapped out where everything was and labeled everything and made it as accessible as possible for them to go through. So I feel, at a certain point, you do have to be organized. On one level, if you clearly give someone something and it's right in front of them and they didn't fucking read it, but they had the information, they had the evidence, then you can say they didn't look very hard. But on another level, if you know you're not organized and you info dump on them, you can't, put someone down for not processing what is buried in. Like, my concise document is 97 pages. I had hundreds of pages of material for the EEOC to go through. So you can't expect the human minds to process and be able to spend and you can't expect them to spend resources on going through hundreds and hundreds of pages, for example. So, you do have to place some responsibility on how are you organizing this. But if you organize something in a certain way and did give it to them and they didn't fucking look, then I guess you could make that conclusion. But because of the statements that we've seen he's made previously, if the way he organized anything to those judges was remotely like the other statements we've seen in this document, then I could see why he may not have communicated in a way that the judge was able to access the information if it did exist, Alright, so anyway, let's keep reading these statements. My bad. So the statements include but are not limited to: the 4th Circuit did not look very hard. The 4th Circuit rendered a feckless decision. The baseless and flawed decision by the trial court, and the 4th Circuit's illogical and vulgar blessing of the trial court's action. The trial court's error is glaring and perverts the procedural laws. This court must correct the 4th Circuit's unanimous error wherein 3 Court of Appeal judges could not see or did not want to see how corrupt the trial court's decision would be and its effect on later lawsuits. The Fourth Circuit Court of Appeal was blind to the error. Not even in St. Bernard Parish can this atrocity be allowed to stand. And you know what I wanted to pull up, though? I was going to pull up from The Big Lebowski, the scene or like a little clip where he's like, this aggression will not stand. But I forgot to do that. Anyway, also, I have feelings, of course, as you know, when people use disabilities in ways to negate or discriminate in certain things. So I don't like that blindness is used in this context this way, but whatever, we're going to keep going. So it says, this court did not consider respondent's writ pursuant to Supreme Court rule, the 7th or some shit like that. And Justices Christensen and Crane concurred. No clue if I said that right. Sorry. Noting the conduct was a blatant violation of the court's rule prohibiting discourteous language under Rule 7, as well as General Administrative Rule Part G11, which requires lawyers to speak and write civilly and respectfully in all communications with the court. On January 6, 2022, respondent filed a pleading captioned Memorandum in support of plaintiff's applications, motion for recusal of Judge Darren Roy, Judge Division D, 34th Judicial District Court. You know how long all of the names for these fucking documents are, man? It really reminds me of, like, in New Orleans, certain churches will have the longest names ever. They'll be like, Jesus Christ Church of Holy God, Mother Teresa, Hallelujah, Amen, Glory be to God. Some shit will be the church name. I'm just kidding, but whatever. That's what the names of these, like, documents remind me of. Like, they're so fucking long. It's like, can we just call this Exhibit A? Fuck. The caption did not get that right. I'm hoping that the other one is working this time. Okay. So, next up, it says, did I read this? No, I'm going to read it again. On January 6, 2022, respondent filed a pleading, captioned Memorandum in support of plaintiff's applicant motion for recusal of Judge Darren Roy, Judge Division D, 34th Judicial District Court, which contains statements that include, but are not limited to, it appeared that neither did the Judge Darren Roy seem to care, as it was not apparent that he even bothered to look at the pleadings Randazzo filed. Judge Roy's favoritism of Sidney D. Torres II and Lena Torres Nunes was on full display. Judge Darren Roy wants to hold on to this case. Judge Roy desperately wanted to make decisions on May 6, 2021, and then May 27, 2021, or else he would have, without hesitation, recused himself. Why is Judge Darren Roy so desperate to stay as the presiding judge in the corporation lawsuit? So why would Judge Roy recuse himself, though? I feel like he needs to explain if there's a connection between Judge Roy and Sidney Torres. Maybe there's a connection that I'm unaware of that all of the attorneys in this space know. But, like, other than that, I feel like for the public record purposes, it should be made clear. Like, you know what I mean? Like, if there was a reason for Judge Roy to recuse himself, this gentleman is not making clear why. So, for example, I believe that in the Supreme Court for the government, Neil Gorsuch should recuse himself with anything dealing with Philip Anschutz, because Philip Anschutz is one of the biggest donors for Neil Gorsuch on the Supreme Court. And I believe that that is a reason to recuse yourself, because it's a conflict of interest to be making judicial decisions for the person who is why you're in the court. You know what I'm saying? But he never fucking does recuse himself. So, but in that situation, right, like, there's a clear paper trail of the money. There's, like, clear evidence as to why this guy should be recused, right? And so, like, there are times where I do believe a judge should recuse himself. But whenever you're not explaining why you're just like, this judge is taking sides. Well, the judge is supposed to make a ruling in one side or the other. That's what the fuck a judge does. They judge. Like, you know what I mean? So if you're not explaining why a judge should recuse himself, it just looks petulant and petty in my opinion. But anyway, so next up, another statement that Mr. Salvador had made was, Judge Darren Roy's conduct was not negligent, but was intentional. Judge Darren Roy did not make any simple mistake. His actions have been calculated and conniving and have caused serious damages to Salvador J. Randazzo. So, obviously, Mr. Salvador thinks very highly of Mr. Darren. And so then it says, on March 11, 2022, respondent filed a pleading with the Fourth Circuit regarding the recusal proceeding conducted by Judge Hans Lucheberg ad hoc. Sorry, I'm saying that way wrong. Which contains statements that include, but are not limited to, judicial integrity has reached a new low. Judge Lucheberg ignored the ethical and codal provisions in order to rule that Judge Roy may keep these proceedings in front of him. Judge Roy's action of filing 2 complaints are obviously spiteful and hateful acts beyond any legitimate courtroom procedure concern or judicial integrity concern. So I'm just going to pause right here. I think it's really entertaining because unless there is other information to the contrary, which just is not made available to me at this time, from right now it comes off as if, you know, Mr. Salvador is pissed off that Judge Roy is holding him accountable for his own behavior. You know what I'm saying? Because, like, what? Because Mr. Salvador doesn't understand why what he's saying is disrespectful and literally against the professional rules of conduct. Like, what? And there's a difference between intention and impact, right? Like, so, you know, some of the statements, not all of the statements, a lot of the statements are like definitely like, no, this is just 100% disrespectful. What the fuck, dude? Why would you think this is okay to say? Some of the statements that were made, though, he probably could have gotten away with some of that shit just basically if he had basically was playing more of the card of just like, oh, I was being a little too blunt, I'm so sorry, and backtrack after. He could probably have gotten away with some of the shit he said, but some of the shit he said was like very disrespectful. You know what I mean? And all of it together doesn't look good, in my opinion. But anyway, okay, so then it says that he said, a cloistered lifetime of handling misdemeanor cases and traffic offenses in a nook in the St. Bernard Parish DAs didn't sufficiently prepare Judge Roy to act as a district judge as he claimed when he was running for the Honorable Kirk S. Vaughn's seat in Division D. So basically, he's trying. So right there, you see right here where it's these types of statements right here alone, in and of itself. This statement alone, it is disrespectful, but at the same time, it's not disrespectful enough. So like everybody can have an opinion about what somebody did, right? And so if it were facts that he handled misdemeanor cases and traffic offenses in St. Bernard Parish, you know what I mean? These are facts that he's speaking on. It is true that he seems to be demeaning the St. Bernard Parish District Attorney's office that handles those cases. He seems to be kind of looking down on those cases in this situation, you know, and on that entire parish court system, if I'm not mistaken, from this interpretation of the wording. But it seems like he's trying to put down Judge Roy while uplifting Honorable Kirk S. Vaughn here, Judge Vaughn. So in this situation, if it was just this statement alone, for example, this is where I was talking about where just this statement alone, he could probably backpedal on some of it and just basically be like, yeah, I just really respected Honorable Judge Vaughn so much, nobody could live up to him. He could say some shit like that and probably get away with it if it was just one statement like this alone, right? But all of these statements together, he just keeps burying himself into a digger hole. And then kind of acting like none of that was unprofessional. The fuck? It's like when at the law office that I filed my complaint against, they were calling me unprofessional. But in my opinion, I don't understand what the fuck I ever did there that could have been perceived as unprofessional. The most unprofessional thing about me is that I will curse. However, I never go into a job cursing, ever. I only curse at a workplace after other people are cursing, if it's normalized in the culture, and people tell me I can curse and it's fine. Then I might fucking curse, but I would never curse, like, to who we're representing, When I've worked at law offices, I've never cursed in front of, like, other attorneys that are outside the firm or clients or things of that nature. No matter what job I'm in, I would never curse out the customers or the clients or anything like that, and I would always keep it respectful. I never curse anybody out. But it's like sometimes, you'll be in situations, like I was in a situation, they were all cursing. They were cursing me out. Then they were like, we're cool here, you can curse. And so then the most unprofessional thing I did there would probably be cursing. But yeah, so whenever I called them out for discrimination against me, and they were trying to convince me that I resigned when I never resigned. They were claiming that they would have fired me because I'm unprofessional. And so I tried to understand and get feedback on what was unprofessional about me, but they couldn't give me any feedback. And so it doesn't come off as if they're actually trying to criticize something about me. It comes off as if they're just insulting me for no reason, because like, if you have something for me to improve on, if there is something unprofessional about me and you're not telling me what that is so I can be better, then it's not constructive criticism. It's just an insult, in my opinion, right? And I feel like that's very much in every statement that Salvador made that's documented, that's how it is. But he's trying to act like there's nothing wrong with what he's saying when there very much is. You know what I mean? He's kind of doing the same thing that the HR at that law firm did to me. He's trying to do that to the judge, except for an attorney trying to fuck with a judge that way really isn't going to go in your favor, in my opinion, because it's messing with your career. It's messing with your future cases. Like, I don't understand. Like, why would Mr. Salvador do this? Like, you know what I mean? Look at what he's doing with relationships here. He's having a case filed against him where he's damaging his relationship with a judge, which could therefore harm his ability to do business in general, right, as an attorney, for any case under that judge. And nothing against the judge, but it's just more of like, I do believe that when an attorney and the judge are filing complaints against each other, that any other case that could end up in the judge's court would have obstacles when it comes to communication between the judge and the client, which would be necessary. But the judge and the attorney, which would be necessary for the client, right? Like, so, I just think it muddles the water. But at the same time, though, if a judge and an attorney were filing complaints against each other, would they then get assigned to each other again, or would there be workarounds to avoid that? That I don't know. You know what I mean? I don't know how that works. But yeah, but say there wasn't a workaround, then what? You're really shooting yourself in the foot there. And, with the whole fucking, like, fighting with your family, suing your family, and then fucking with a judge as an attorney, that's like a self-destructive path, in my opinion. So actually, if anybody that actually cares about Mr. Salvador Randazzo watches this shit, some people should check in on him, because, like, is he okay? Like, he's self-destructing, in my opinion. Or he was then. Is he still just self-destructing now? Who knows? He just got suspended a couple months ago, so maybe he is. I don't know. I hope he's alright, though. Alright, sorry about that ramble. Let's keep going. So, on March 24th, 2022, the 4th Circuit denied respondents' writ application. In April 22nd, what the fuck is wrong with me? I don't know if I'm saying these dates right. That's my bad. In April 2022, did I say March 24th, 2022, right? Or what the fuck? I said 2022nd. I just looked at the captioner. What the fuck is wrong with me, y'all? I don't know. Ignore me. Okay. I know how to read a damn date. Okay, don't look at me that way. Okay. On March 24th, 2022, the Fourth Circuit denied respondents' writ application. And yeah, because what the fuck was that garbage? In April 22nd, god damn it, I just did it again. In April 2022, respondent filed with the court of, I'm not speaking right, with this court a pleading, captioned application for supervisory writ or writ of certiorari, don't know what the fuck that means, and review to the Fourth Circuit Court of Appeal, State of Louisiana docket number 2022, C0158, 34th JDC, Parish of St. Bernard, State of Louisiana, docket number 2015-1017. Honorable Hans Lugeberg, Judge ad hoc, presiding judge, which contains statements about Judge Roy and Judge Lugeberg that include, but are not limited to, recording of all undersigned counsel's calls and then dangling them in front of the Office of Disciplinary Counsel is an obvious intimidation tactic. I'm gonna pause here. How is that an intimidation tactic? Okay, so my last job that I worked at, I made mostly a lot of phone calls. All of my phone calls were recorded and I loved it. I loved it. Because anytime I had a problem, I immediately call my manager, go listen to that call, please and thank you. It protects your ass, it covers your ass. If you are doing what you're supposed to do, being recorded is like, it protects you. It's never a good thing. The only time I don't want to be recorded is when I need to go wipe my nose, when I need my privacy for, like, I'm disgusting, don't look at me, I'm Gollum type shit, other than that, though, when it comes to my work, I love being recorded because first of all, I can go back and look at how I performed and I can improve. Second of all, I can have evidence of what I'm doing on my end. Like, you know what I mean? Like, I'm doing what I'm supposed to do. And I love having evidence for that. So, how is being recorded an intimidation attack? All calls are recorded for training purposes and, you know what I'm saying, and monitoring purposes. You know what I mean? Like, I don't know. I just don't understand that. Like, how would recording you be intimidating to you unless you knew you weren't acting in good faith? You know what I mean? Like, I'm just saying, nobody is intimidated by being recorded. Unless you just generally don't like being recorded in general, but that's a different conversation. But outside of that, you know what I mean? I feel like the only time people don't want to be recorded is when they don't want something documented for what they're doing because they know it's wrong. Because, like, you can't be intimidated by being recorded if you're doing what you're supposed to do. Like, it just doesn't make sense to me. Okay, I'm going to keep going. It says, every time undersigned counsel entered Division D before Judge Roy, he exhibited a bias and prejudice against him. What was the bias and prejudice, though? So for me, the reason I believe I was discriminated against for my mental health was I was denied accommodation for my deafness and mental health processing. Then after I was denied an accommodation, which is literally I just need more time to process in order to provide a more socially acceptable answer and to understand what was happening because of how my mind works. So that was denied. Then I had a panic attack because the conversation was escalating and triggered other things for me related to my mental health trauma. And I was sent home. Well, after I was sent home, I was removed from the digital office. I was removed from Slack and from the Facebook business and things of that nature. And my email was changed. My email password was changed. And I couldn't get into my email or into Slack or anything. And I had never quit. And so I didn't want to quit. And they were firing me. And, and I believe I was being discriminated against because of being denied those accommodations. And because of how they treated me, they were firing me as retaliation, in my opinion, for asking for accommodations and for then having a panic attack, in my opinion. And there was someone else that started around the same time as me. She was in the hospital, and that wasn't a problem. There was another person who was working there that had recently been in a car accident, and so they were not in the office because they were in a wreck and they were recovering. So people with physical injuries, they were treated fine. They were given grace. But if you have a disability that was mental related, in my opinion, you were perceived as, I would feel I was treated as less than because of my mental disabilities, in my opinion. And I believe that I can prove that prejudice and that discrimination from the email conversations I had, that email evidence, and from how other people were treated better than me, who had physical injuries. They were treated good, but with mental disability, you weren't treated well. So I believe that could prove, the prejudice. So like things of that nature where sometimes, I do believe, like, I understand the feeling of when you're like, someone's discriminating against me, when you just take it on face value. A lot of people, they'll dismiss you, and I hate that feeling for people. So I never want to be dismissing what could actually be true for somebody. But when you're not explaining why something is prejudiced or biased, and you're not showing what happened with some form of evidence if possible, if you have neither, then it does just look like you're insulting someone for no reason, in my opinion, potentially. So yeah. So anyway, and then it says the second complaint by Darren Roy to the Office of Disciplinary Counsel is not concerned with Judge Roy's integrity, but rather with doing harm to undersigned counsel. So it looks like Darren Roy is filing all of these complaints against the judges, if I'm not mistaken. So I believe that they are filing complaints against each other, if I've interpreted this documentation correctly. Maybe I should go look for the Judge Roy documentation if it's public. But anyway, then after that it says, on June 22nd, 2022, this court denied respondent's writ application. In his response to the complaint, respondent continued to make statements pertaining to the qualifications and integrity of Judge Roy, and further claimed that Judge Roy is biased and prejudiced against him. At his sworn statement, respondent provided no facts or evidence to support the statements he had made about the judges and the courts in the pleadings, only his beliefs and opinions stemming from the actions and decisions in the litigation. Respondent continued to make statements he knew to be false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of judges, justices, and courts at all levels of appeal. The ODC alleged that respondents' conduct violated rules 8.2a, 8.4a, and 8.4d of the Rules of Professional Conduct, as well as Supreme Court Rule 7 and Supreme Court General Administrative Rule Part G 11. Disciplinary Proceedings. In September 2024, the ODC filed formal charges against respondent as set forth above. Respondent answered the formal charges and denied any misconduct. Accordingly, the matter proceeded to a formal hearing on all. What am I saying on all? The fuck? There's no all here. The matter proceeding to a formal hearing on the merits. The hearing committee conducted the formal hearing on February 24th, 2025. Respondent did not appear for the hearing. The ODC was represented by Deputy Disciplinary Counsel Robin Mitchell. The ODC introduced documentary evidence, including phone records and transcripts, emails to court staffers, pleadings filed by the respondent, and other relevant documents. The following witnesses testified at the hearing: Judge Darren Roy, 34th JDC, Parish of St. Bernard; Hans Liljeberg, former judge on the 5th Circuit and current councilman for Jefferson Parish; Alyssa Lucy Wineski, former law clerk for Judge Roy; Rachel Kessling, administrative assistant to Judge Roy; and Cecilia Meneses, court reporter for Judge Roy. So yeah. Judge Roy brought his whole fucking team with him. He said, let's go, bitches. I wonder where he went to eat after this. So anyway, fucking, it looks like he really fucked up, in my opinion. You know what I mean? Like, I just feel like, in my opinion, it makes it harder for you to get things done for your clients if you're not treating court staff with respect as an attorney, if I'm not mistaken, from what I understand about practicing law. And I'm not an attorney. I've worked at 3 law firms before. My job is marketing. But yeah. But I'm not even drinking this Dr. Pepper, right? Okay, so here's a hearing committee report. After considering the evidence and testimony presented at the hearing, the committee made factual findings consistent with the underlying facts set forth above. The committee indicated that the witnesses provided credible, first-hand accounts of respondents' actions and statements, both written and verbal. Particular weight was given to the testimony of Judge Roy, whose staff members were on the receiving end of respondents' calls and emails. Judge Roy recognized the problematic nature of the conduct. The committee found the testimony of all witnesses to be credible. The committee found the ODC proved by clear and convincing evidence that respondent violated rules 3.5A, 3.5B, 8.2A, 8.4A, and 8.4D of the Rules of Professional Conduct. I feel like I burped, I'm sorry. Supreme Court Rule 7 and Supreme Court Rule General Administrative Rule Part G, Section 11. So, with respect to each rule violation, the committee determined an pertinent part. Rule 3.5. Respondent called Judge Roy's office on at least 8 occasions, at times leaving rambling voicemails and engaging in one-way legal arguments with staff members. Ms. Wineski described a typical call where a respondent would start off much calmer at the beginning of the phone calls, and then he would almost like work himself up because, as you can tell, I'm not saying much, and he is just kind of getting more and more, I don't know, if angry, just loud, worked up, passionate. Ms. Kessling testified that in a typical call from respondent, he would always ask me what he should do, what I thought the judge was going to do, how he should handle that. Ms. Meneses testified that respondent rambled during his calls and complained about the judge and many others involved in the litigation. His phone calls became such a problem for staff, such that Judge Roy issued an order requiring respondent to communicate via email only. Rule 8.2. In 2 pleadings he filed in matters before Judge Roy, respondent falsely accused the judge of purposely withholding service of a court order. Then, in the motion to recuse, respondent included multiple attacks on the judge's integrity. Judge Roy denied the allegations and demonstrated how the court records showed them to be false. Supreme Court Rule 7, or something like that, and Supreme Court Rule Administrative Rule Part G, Section 11. I don't know if I'm saying any of that right. Respondents' pleadings contain numerous false statements and accusations about the qualifications and integrity of Judge Roy, Judge Luchiberg, and the judges of the Fourth Circuit, all of whom denied respondent the relief he sought. In his application to this court, he launched a broadside against the 2 lower courts. His memorandum supporting his motion to recuse Judge Roy was little more than a vehicle for respondent to vent his spleen against the judge. In his application to the Fourth Circuit, he sought review of Judge Luchiberg's ruling on the motion, and again used the occasion to attack the ethics and integrity of Judge Luchiberg and Judge Roy. Rule 8.4. Taken as a whole, respondents' egregious accusations, ad hominem attacks, and numerous and improper ex parte contacts violated this rule. He abused the legal process and prejudiced the administration of justice in 3 different courts with his personal agenda against sitting judges. The committee found respondent intentionally violated duties owed to the legal system and the legal profession. He repeatedly attacked the qualifications and integrity of Judge Roy, and his clear objective or purpose was to obtain favorable treatment from the appellate courts. His conduct continued after being admonished in the concurring opinions of this court. He repeatedly engaged in improper ex parte communications with Judge Roy's staff. His calls with court staff contained implied threats, improper and inappropriate statements about the litigants and counsel, as well as improper questions and statements about procedure, legal strategy, and Judge Roy's opinions on issues. He caused actual harm by impugning the integrity of sitting judges, making false statements, attempting to manipulate the judicial process with threats and coercion, abusing the appellate and supervisory jurisdiction of the courts, and engaging in improper ex parte contact with court staff on multiple occasions. Relying on the ABA's standard for imposing lawyer sanctions, the committee determined that the baseline sanction is disbarment. The committee found that the following aggravating factors are present: a dishonest or selfish motive, bad faith obstruction of the disciplinary proceeding by intentionally failing to comply with rules or orders of the disciplinary agency, refusal to acknowledge the wrongful nature of the conduct, and substantial experience in the practice of law, admitted 1982. The committee found no mitigating factors are present, noting that respondent did not submit any evidence to support mitigation. Turning to the issue of an appropriate sanction, the committee noted that this court has addressed cases which involved similar instances of attorney misconduct, and only one case resulted in disbarment, which is the baseline sanction in the ABA standards for intentional misconduct. The committee determined that respondent's conduct, while serious and sanctionable, does not warrant disbarment. Considering the facts and circumstances of this case, and following the analogous decisions of this court, the committee concluded that a lengthy suspension is warranted. Accordingly, the committee recommended that respondent be suspended from the practice of law for 3 years, with 18 months deferred, and that he be assessed with the costs and expenses of this proceeding. Neither respondent nor the ODC filed an objection to the hearing committee's report. Therefore, pursuant to the Supreme Court Rule, I think this is 19, Section 11G or some shit like that, the disciplinary board submitted the committee's report to the court for review. Discussion. Bar disciplinary matters fall within the original jurisdiction of this court. Louisiana, some bullshit here, I can't cite this, fuck that. Consequently, we act as triers of fact and conduct we act as triers of fact and conduct an independent review of the record shit to determine whether the alleged misconduct has been proven by clear and convincing evidence. And then it's citing some other shit here, fuck that. While we are not bound in any way by the findings and recommendations of the hearing committee and disciplinary board, we have held the manifest error standard is applicable to the committee's factual findings. Citing some other shit. The record establishes by clear and convincing evidence that respondent filed pleadings containing statements about a judge which he knew were false, or showed reckless disregard of the truth, and engaged in inappropriate communications with a judge's office. This conduct violated rules 3.5A, 3.5B, 8.2A, 8.4A, and 8.4D of the Rules of Professional Conduct, Supreme Court Rule 7, or something like that, and Supreme Court Administrative Rule Part G, Section 11, I think. I don't know. Or is it Court Rule 7, Section 7? I don't fucking know, man. As charged in the formal charges. In determining a sanction, we are mindful that disciplinary proceedings are designed to maintain high standards of conduct, protect the public, preserve the integrity of the profession, and deter future misconduct. And it's citing some other shit. And then it says the discipline to be imposed depends upon the facts of each case and the seriousness of the offenses involved, considered in light of any aggravating and mitigating circumstances. Citing some more shit. Respondent violated duties owed to the legal system and the legal profession. His actions were intentional and caused actual harm. The baseline sanction for this type of misconduct is disbarment. The record supports the aggravating factors found by the hearing committee, and no mitigating factors are present. In the court's jurisprudence addressing similar misconduct, only one case resulted in disbarment. That case, which is cited here, but fuck that, involved an attorney who launched a lengthy social media campaign to affect the outcome of a case she was handling, and she used social media to induce and encourage ex parte communications by the public and disseminate false and misleading information about the presiding judge. Unlike McCool, the audience for respondents' false statements was essentially limited to judicial staff and presiding judges in the courts. More often, we have imposed a period of suspension that ranges from 1 year and 1 day to 3 years. And something else is cited here, and it also says in quotation marks, 1 year and 1 day suspension imposed upon an attorney who made unsubstantiated, disparaging remarks about a judge and opposing counsel, engaged in ex parte communications with a law clerk, continued to file duplicative pleadings after being ordered by the court to refrain from doing so, and removed the case to federal court solely for the purpose of delay. And then it cites something else as well, and in parentheses here it says 1 year and 1 day suspension imposed upon attorney who made a false statement about the integrity of a judge, filed improper pleadings, and failed to follow court procedures. And then another case here is cited, and in quotation marks, do I keep saying quotation marks instead of parentheses? I just realized that. The fuck, man? I totally know the difference. I don't know why the fuck I do that. In parentheses, god damn it, it says 1 year and 1 day suspension with all but 6 months deferred, imposed upon an attorney who made statements in a writ application accusing district and appellate court judges of incompetence and or corruption, and suggesting their decisions were driven by political gain. And another fucking case is cited here, and in parentheses it says 3-year suspension with all but 18 months deferred, imposed upon an attorney who filed repetitive and unwarranted pleadings in ongoing litigation and made frivolous and harassing claims for discovery against persons not involved in the litigation. And then another fucking case is cited. How many cases do you need to cite to compare, like, to prove why you're giving the punishment you're giving? Like, damn, we get the point. But anyway, another one is cited, and in parentheses it says 1 year suspension imposed upon an attorney accused a judge of being dishonest, corrupt, and engaging in fraud and misconduct, and caused his unfounded accusations to be published in the local newspaper. Damn. Oh yeah, and I realized too, whenever I confuse words sometimes, I think that has to do with my language deprivation and language disfluency from being deaf. Anyway, so there it says, then it says, here, the hearing committee has recommended a 3-year suspension with 18 months deferred, which falls within the range of sanctions we have imposed for similar misconduct. We agree that the recommended sanction is appropriate. Accordingly, we will adopt the committee's recommendation and impose a 3-year suspension with 18 months deferred. Decree. Upon review of the findings and recommendations of the hearing committee and considering the record, it is ordered that, Salvador Randazzo, Louisiana Bar Road number 01551, be and he hereby is suspended from the practice of law for 3 years, with 18 months deferred. Any misconduct during the deferral period may be grounds for making the deferred portion of the suspension executory or imposing additional discipline as appropriate. All costs and expenses in the matter are assessed against respondent in accordance with Supreme Court Rule 19, Section 10.1, with legal interest to commence 30 days from the date of finality of this court's judgment until paid. I don't even know if I'm citing that shit right. Who fucking knows? And then a couple of the judges dissented against this apparently. So yeah. Alrighty, I think that is it. So, in conclusion, that case, a lot happened there. But, from what I'm understanding, it looks like Mr. Randazzo was originally suing his family about a case regarding inheritance and deaths in their family. And so then after he sued his family, which would be your backup plan for the business, right? Because they have the family business, the King Cake family business. So there goes his backup plan for the nepotism. Because now he said a bunch of fucked up shit about and to a judge, on top of trying to get the judge's influence in a case, in my opinion. And if I'm understanding all of this correctly, right? And so, not only is he fucking up his relationship with his family, now he's fucking up his relationship with courts. Like, he literally pissed off the entire St. Bernard Parish Court District, or whatever, if I'm not mistaken. He had all of Judge Roy's staff testifying against him, you know. So he's fucking up his relationships with his family. He's fucking up his relationships with work. He really seems to be on a path of self-destruction, if I'm understanding this correctly. And I was just fascinated by this case because this is such a huge family in Louisiana and New Orleans. Like, the Randazzo family is fucking huge. And I was also fascinated with watching this case, with looking into this case too, because, like, why would you do these things to yourself? You know what I mean? And so, yeah, no offense to you, Mr. Salvador, if you watch this shit, or take offense, because I don't know, man, how you behaved, and all of that's true, is kind of fucked up, man. But, like, I'm just fascinated with this shit. I feel like this guy is potentially not in a good mindset. Like, reasons that I could think of for behaving this way is perhaps, you know, if it's like comes from your own family trauma and it's how you learn to behave based on how you were taught to be. But at the same time, I don't understand what could happen for you to sue your family this way. But yeah, so, you know, and if he hadn't sued his family, maybe his backup plan could be, you know, that King Cake family business. But I mean, maybe he can still go out on his own. Maybe he's doing it on his own type shit with the King Cake. Hold on, let me pull back up that King Cake situation. I should have just clicked. Let's see. Okay. So, Mr. Salvador, the King Cake, my understanding, the King Cake situation that he was involved with closed, if I'm not mistaken. Didn't the Good Children Bakery get destroyed in Katrina? So, yeah, like, I don't know. I feel like he basically sued his whole family on the King Cake side that, you know, that could have helped him, because Manny Sr. And Lawrence Randazzo were the names listed for which I believe he may have been the executioner of the estate on. And I believe he was suing his family as it relates to them, if I'm not mistaken, or something like that. So yeah, that's the thing. Like, he was suing. Let's bring that back up just to recap real quick. Apologies. So Mr. Salvador Randazzo, he was the executor for the succession of Lawrence Randazzo, right? Lawrence Randazzo, looking at this family tree here. So Salvador Randazzo, I believe, is a descendant of Lawrence Randazzo, but he was suing the estate of Manuel Randazzo Sr. in the Randazzo property situation. So this original lawsuit comes from Lawrence Randazzo family against Manuel Randazzo family. You see what I'm saying here? You look at that family tree, if I understand correctly. Oh, I just realized I'm not showing the full version. But yeah, so yeah, just, putting that into context here, the family drama. So I believe Mr. Salvador Randazzo is a descendant of Mr. Lawrence Randazzo, if I'm not mistaken. And I believe that on behalf, like, when it came to executing the estate for his father's will, he ended up suing his uncle, if I'm not mistaken, and his cousin's side of the family on the Manuel Randazzo side, if I'm understanding the beginning of the underlying facts correctly. You know what I'm saying? So yeah. So Mr. Randazzo, I mean, maybe he could still go on board with item number 5 here. Maybe if Nana Randazzo, if he didn't fuck up his relationship with Nana Randazzo's, maybe he can still get back in with his king cake family business and go work for Nana's while he's suspended from the bar. Like, I don't know. Like, what the fuck would you do? What does an attorney do when they are suspended or disbarred? Do you get a new career path? Like, I had suggested previously that perhaps if an attorney was suspended, they could see if another attorney would be willing to hire them for some bitch work. But, like, what do you do as an attorney getting suspended? Like, yeah, so the Randazzo family tree, like, it has been infamous in Louisiana and the New Orleans area for literally, like, twice my lifespan. Because I'm 31, I'm about to be 32, so, yeah, like, they've been around this block, way longer than me, but, shit, man, I mean, my dad, he was born in 1964, I think, and so, this thing was, like, they started their first fucking king cake bakery in 1965, that's, like, almost as long as my dad has been alive, like, yeah, so, their king cake family tree, they're huge in Louisiana. I'm spiraling. I'm cycling. I think I'm going to try and end this shit. I was going to try and give you guys a recap, but, like, so it's just so much information here. But yeah. Yeah. I feel like it's interesting, it's an interesting case study to look at. But basically, just to kind of sum it up, give you something here, we looked at this situation. I was originally looking at how other cases were handled in the context of recently filing my own case. I was curious, like, would my case potentially be handled in a similar way as other cases were? And in that situation, I found this case stood out to me because of how big the Randazzo family is in Louisiana. And then as I was reading it, I was entertained by how wild the statements and the accusations were. But also, I felt like I had to cover it too because it didn't, whenever, I always say this, like, it doesn't compute to me. Why would somebody fuck with your own business this way, right? Usually, self-destruction for me, I see different paths. When people take paths of self-destruction, sometimes it can be because the community you built your life in isn't a safe community for you to be in. And so sometimes how you remove yourself from that community could be self-destruction in a way. I've seen that a lot, but then also in other situations, I feel like when someone self-destructs, there's often something that's not being addressed here. Even if them self-destructing is problematic and it doesn't excuse or invalidate the impact of what they do, but whenever someone is self-destructing in this way, I am very curious as to what is the underlying cause and to how to fix that issue. Because for me, I think it's about the concept of, like, how do we improve as people, right? Because I've been working so hard to try and, like, just be a better person than I used to be. That whenever I see people that I feel like are repeating some of the same self-destructive habits that I know I used to have, it makes me want to fix it. And I know you can't fix everybody and stuff like that, but I think that's why I'm so caught up on the situation, like why it caught my attention. But yeah. So yeah, thank you for watching. Thanks for your time tonight. I appreciate you guys. It's been a weird one, but I always enjoy just like getting the chance to process. And it does mean a lot to me that you guys, even though it's just a few people usually, but who cares? Like, just having one person watch my shit does mean a lot to me. You know what I mean? So I really appreciate you. Thank you for watching. Thank you for being here. I hope you have a great night. And yeah, bye. Thanks for watching. Join the loyalty program at noladeathchild.com/loyalty and check in during live streams to get points for rewards.